and welcome to the Big Debate, where we provoke and inspire actions and reactions in the interest of justice. My name is Willis Haki, and this is Justice Dialogue. Oftentimes, when you think about perpetrators of injustice, certainly you have almost never imagined an injustice that happened at the bosom of the judiciary, in the hands of the very people we look upon to uphold justice and protect the rule of law. And if you're still wondering, what if I told you of an inmate who is currently serving in prison without a sentence? And before we jump into the details, let me invite the special attention of the Chief Justice. And to the viewers, you too can help the victim to voice out for justice. Simply subscribe and share the video. Into the details. In the criminal case number 534 of 2007, Lawrence Mushina Ngugi was charged, tried, and found guilty of the offense of defilement of a minor of 15 years, contrary to Section 8(1), subsection 3 of the Sexual Offences Act, 2006. But while passing the sentence, the trial magistrate committed what I would call a transpositional error of law in her mind. She correctly found conviction under Section 8, subsection 1(3), but erroneously stated the same as though she was reading from Section 8(1), subsection 2. Just to quote her judgment, at page 46, line 46, she stated as follows: the offense that you committed is one that under Section 8(1), subsection 3 of Sexual Offences Act has only one penalty, and that is life imprisonment. Now, for purposes of information, punishment under the offense of defilement has been graduated based on the age of the victim, so that a victim of 11 years and below attracts a penalty or a punishment of mandatory life imprisonment. A victim of between 12 and 15 years attract a punishment of not less than 20 years imprisonment. And a victim of between 15 and 18 years should attract a punishment of not less than 15 years. Now, when the trial magistrate states that Section 8(1), subsection 3 has only one penalty, and that is life imprisonment, clearly in her mind, she was reading from Section 8, subsection 1(2). And that is the one that provides for mandatory life imprisonment. So the net effect of this transpositional error is that the victim, in this case, in this injustice, Lawrence Mushina Ngugi, was slapped with life imprisonment instead of 20 years imprisonment. Now, 14 years later, Justice Murina of the High Court, via constitutional petition number 17 of 2019, identified this error. And in his ruling, paragraph 21, page 21, paragraph 55, he stated as follows: this court has by now agreed that the sentence as rendered by the trial court and eventually confirmed by courts of appeal is unconstitutional. As such, the sentence cannot stand. The effect thereof is that the petitioner stands convicted but not sentenced. Those are the words of Justice Murima of the High Court. Now, Justice Murima went ahead to state as follows at page 22, paragraph 5. An order of judicial review by way of certiorari be and is hereby issued to bring into this court and quash the sentence of life imprisonment passed against the petitioner. Further directive at page 23, paragraph 6. The petitioner herein, Lawrence Oshina Ngugi, shall be presented before Principal Magistrate Kikuyu Law Court for proper sentence. Now, for me, two reasons makes this injustice stand out. The petitioner to date has never been given the proper sentence as directed by the High Court. Since 2019, today we are in 2024. The second reason that makes this injustice outstanding is that if proper sentence were to be availed to this victim today, processed through the remission provisions, would mean that this petitioner would have served his full sentence by the year 2021. So, this also means that since 2021 to 2024, this petitioner has been serving an unlawful custody. Now, allow me to get the second opinion of an expert. And my guest in the studio today is Ruth Vuchocho. Ruth Vuchocho is an advocate of the High Court. Good morning, Wakili.
Good morning.
Welcome to the show.
Thank you so much for having me.
I had shared with you copies of the proceedings.
Yes.
What would you say about the predicament of this young man? And who could be at fault? Or who is to be blamed, if at all?
I've had a chance to look at the proceedings, to look at the judgment from the trial court up to the High Court, up to the Court of Appeal, and ultimately at the Constitutional Court. And indeed, in my opinion, it's quite sad. And it's quite a sad state of affairs. I feel for the young man who I believe is going through a lot of psychological trauma, from especially after the entire process, knowing that he may have already served his full sentence and is now in unlawful custody, unfortunately. The criminal justice system definitely provides for a means for an offender to purge his guilt by serving a particular punishment and does not envisage a situation where the offender would be committed to prison without a prison term, as is the case in this unfortunate situation. Clearly, this kind of error is regrettable, if I'm to say anything about it. The same should have been abated as soon as a decision came from the Constitutional Court and direction given by the Constitutional Court. However, it's quite unfortunate that up to now, that has not been done. As to who is at fault, of course, it's normal for judges and magistrates to make errors, and that's why the judiciary has its own internal appraisal mechanisms. But then the inordinate delay by the trial court to correct the error appears to perpetuate the error instead, and it also normalizes the injustice with its torturous effects on the young man, which is quite unfortunate.
We understand that the petitioner has never received any formal communication from the magistrate court as to the fate of that directive of the High Court. Mm-hmm. Is there a chance that the magistrate may have rejected the directive of the High Court? And if at all, and maybe this is not just for the petitioner, even the law students may be interested to know what would be the legal and jurisdictional authority of the magistrate to countermand the authority of the High Court.
Ordinarily, an order from the High Court to the magistrate would arise from an argued and very reasoned question of law, and therefore it is binding on the magistrate court, which invariably deals with the matters of facts.
Wow. We've seen the correct reading of the provision that that the magistrate based her conviction. Section 8(1) subsection 3 provides that upon conviction, the offender shall be liable for a penalty of not less than 20 years. Since the law appears to provide the minimum of 20 years, don't you think the life sentence which he was given is well within the range of her discretion and therefore within the law? Just to be fair to the magistrate.
When convicting and sentencing, the trial magistrate must begin by correctly stating the law that she purports to rely on. Now, in the present case, the magistrate started by erroneously stating that according to her, only one penalty is provided by the law, and that is life imprisonment. This is in accordance with subsection 3, and that is according to her. Now, had the magistrate stated that she was using her own discretion to enhance the life imprisonment, the argument would have been totally different and would have totally taken a different turn altogether. Discretion is normally granted out of recognition that some cases may involve aggravating circumstances. And such circumstances may include issues such as STDs that arise from a sexual offense such as this, among others, or grave bodily harm. And in the opinion of the court, the endangered life of the victim may be used to enhance the punishment.
Do you mean to say that a judge or a magistrate cannot exercise discretion because she has liberty to do so under the law?
Oh yes. There is a guiding rule that must be followed to justify as to why a magistrate may depart from the minimum punishment prescribed by the law. And in fact, there is a supreme law on this. Article 50 of the Constitution of Kenya prescribes that every person is entitled to the least severe of the prescribed punishment by the law. Now, what does this mean? Is that in the absence of such aggravating circumstances as in the present case, the least prescribed is the 20-year imprisonment. Remember, the High Court, by virtue of its jurisdiction, is considered a more proficient court. This means that it is a higher court if you were to compare it to the magistrate court. And such a matter of interpretation and application of law must have been at play before the High Court judge sat down and arrived to the decision that he was to outlaw the initial penalty.
To be honest with you, my choice for you was very deliberate as a female expert. Listening to the petitioner, there is general feeling of suspects of sexual offense under sexual offenses that the last thing they want is to be processed by a magistrate, by a female magistrate or a judge. And to be fair to them, it's not uncommon to find female magistrates and judges at such gender forums, activism forums, do you think they have a genuine concern? Or put it this way, do you think the need to promote the talents would compromise the duty to achieve a rectitude decision?
Well, thank you for that question. It is indeed quite an interesting question. It has come up on so many different forums. I believe that a judge or a magistrate must be able to divorce themselves from personal prejudices, especially when dealing with such cases and in discharging their professional duties. And since the High Court has overturned the sentence, I want to believe it was an honest mistake.
Wow. There you've heard it from our expert, Ruth Vuchocho, an advocate of the High Court. And like the famous jurist proposition says, when a law errs, it errs too far. This indeed is an error of law that has gone too far. The damage has been done, but there is an order of the High Court, an order to another court of inferior jurisdiction. This reminds me one Masengeli and the duty to obey the court order. When all were armed, including the judiciary, because he had refused to obey the court order. And while it is a duty for every subject to obey the law and the court order, it should be the DNA of the court and the judiciary to obey its own orders. Over to you, Madam Chief Justice. The buck stops with you.